Chris Casteel in the Washington Bureau of the Oklahoman. The U.S. Supreme Court on Tuesday heard oral arguments in the Hobby Lobby case about the birth control mandate that's part of the Affordable Care Act. And the 9 justices were sharply divided over some of the major questions in the case, particularly over whether the government can require for-profit corporations to provide all of these contraceptives. There's like 18 contraceptives for women that are part of the mandate, even if those contraceptives violate the religious beliefs of the owners of a family-owned business. And that's a threshold question in this case, and one it seemed like the majority of the justices were going to resolve in favor of Hobby Lobby and a Pennsylvania furniture making company, that for-profit companies can at least make a claim in court that their religious beliefs are being violated by a federal law. So it was actually, once they got past that part, and that was highly in dispute in the oral arguments, that the justices touched on a lot of things. And it's hard to ever extrapolate from oral arguments how the court might rule on a case. There are 9 justices. It can be 5-4 a lot of times in controversial cases like this. And it could very well be in this case, and often in very close cases in this court, Justice Anthony M. Kennedy proves to be a swing vote. And he was interesting today. He asked some very tough questions of both sides today. It was Justice Kennedy who asked the government's lawyer, is it your position, is it the government's position in this case that the government can require for-profit corporations to fund abortions, to fund at least the insurance policies that then pay for abortions? And the Solicitor General, the government's lawyer in this case, said, well, it basically is our position that a for-profit company can't go to court to vindicate its religious beliefs. But he went on to say that, we don't think this is abortion. In fact, the Affordable Care Act says that, we can't require abortions. But then Chief Justice John Roberts said, well, isn't really that's what this case is about before us, because the families here, the Greens of Oklahoma City who own Hobby Lobby and the Hans of Pennsylvania who own the furniture company, believe that some of these contraceptives effectively work to to cause abortions. And the Solicitor General, the government's attorney, said, well, that's just not normally how we divide, what constitutes an abortion in the United States, is, whether a fertilized egg implants in the womb. But it was a really tough question by Kennedy, again, who could be the swing vote. But Kennedy also joined with some of the liberal justices in questioning Hobby Lobby's attorney about whether this is really, whether the government is really requiring companies to pay for insurance that covers all these contraceptives. Under the law, Hobby Lobby could be fined every single day, a lot of money, I think like $475 million a year, if they have an insurance policy that doesn't cover all the contraceptives. But if Hobby Lobby simply drops its insurance altogether, does not provide health insurance for its employees, about 13,000 full-time employees, then it would pay $2,000 per employee per year as a tax or a penalty or whatever to help subsidize people who go out into the private market, into the exchanges to buy insurance. So what some of the liberal justices said was, look, if you object to providing the contraceptives, just drop your insurance. You don't have to provide insurance. You're not being forced to pay for these contraceptives. You can just drop your health benefits. And Kennedy, again, who could be the swing vote in this case, joined in on that and said, look, let's say it's a wash. He asked Hobby Lobby's lawyer, let's say it's a wash financially for the company. You drop your insurance, you pay the penalties, and it's really not any more expensive to pay the tax or the penalties to the government than it actually was to provide insurance. So it's a wash for you financially. Then what's your case? And that was a tough question, and the Hobby Lobby's lawyer, stumbled a bit in his answer, but basically came back and said, look, that's still a burden on Hobby Lobby for them to for them to not provide insurance. It puts them at a competitive disadvantage, whatever. But clearly, Kennedy, again, who could provide the vote one way or another on how this case is going to go, is really trying to weigh his options in this and ask some tough questions on both sides. The Supreme Court's expected to announce its decision in this case sometime before the term ends in June, and with a case like this, it could very well be one of the last cases, and so it could be mid to late June before we hear.